Good evening or morning or whatever time it is, wherever you are. Not legal advice. Like, comment, subscribe. Please share. Hopefully your animals are watching. I appreciate you being here. Kind of wanted to talk about GTI, MMTLP in terms of, and this is going to be a little broader, it's going to be insurance and class actions. And then I'm going to talk a little bit about Elon Musk and how attorney's fees might play into a class action, which is kind of my premise. Obviously, this is not financial advice, but hopefully you'll get some information, or hopefully it will clarify or give you other questions to ask. Obviously, before I start, since I'm focused a little bit on GTII, at least the start of this tonight. GTI is associated with Alpine. Alpine, I think, are the biggest scumbags on the planet. So the attempted humor today are scumbag jokes. So we'll see how those go on. Why is math like a scumbag? It borrows the one and never gives it back. Okay. A man goes into a bar to drown his sorrows after losing a trial. He shouts loudly, "All lawyers are scumbags." The man next to him says, "I disagree." The shouter asks, "Are you a lawyer?" The other man answers, "No, I'm a scumbag." And last but not least, I feel the same way about lawyers as drug dealers. They are all scumbags except mine. Anyway, wanted to get on to GTII to start off with. So I did a video about the 10th of March. I discussed my communications with GTII. The reason why I disclosed that was because I thought it should be public information. I can't guarantee the accuracy of whatever I'm told, but I wanted to be fair. So if I got information from the horse's mouth, true or false, I wanted to pass it on. So that's kind of what I did. So I think what I discussed at that point in time, and I'll kind of just recap, I'd heard from various sources that GTII had the opportunity to close certain transactions, but they were unsuccessful in doing that. So that concerned me. So at some point in time, I reached out. And by the way, I'd heard that from multiple sources, and there were multiple deals. And my understanding was, although I don't have firsthand knowledge of diddly, but my impression from speaking to the people I did was that a deal could have been done. And I believed, and this is just still my belief, and you could take it with a big grain of salt, that for GTII to move, it needs a transaction. Now, some people believe that GTII might be the subject of a short squeeze. And briefly, Alpine is the prime broker. There is was a short position in GTII. And people believe that, or some people believe, that if Alpine is expelled from the business, that will help the stock, GTII. And I don't know if that's true or not. I've been detailing and following Alpine and their legal maneuvers for quite some time. So I feel comfortable about that. And I don't think anything's going to happen immediately. So I think for GTII to move, they need some kind of transaction. And apparently they've been at least investigating it in the past, and were, to this point in time, have not pulled the trigger. So about February 6th, I sent a letter off to them, had some further communication, was in contact with a lawyer contacted me. I gave them to February 26th to get kind of their S in order. I was contacted, I think, about the 26th or 25th of February by an outside attorney who basically said to hang on. Prior to that, I'd spoken to another large shareholder attorney, and I had communicated with their in-house counsel, the CEO, and a bunch of other people. So there was a lot of communication. So February 26th comes on. I get contacted on or about that by an outside attorney, and basically I'm told to hang in. March 6th, I get a letter, and it basically says they're working on a transaction. They've identified the entity. Things will be reflected in the 10K, which comes out on or before March 31st. So that's where we ended up. Since then, I've had additional communication with the GTII personnel. And the attorney who's representing GTII, his name is Mr. Fattal, Fattal. How do I know he's representing GTII? Because he represented that in a letter. And besides the letter, why do I believe he's representing GTII other than that he told me? Because I communicated at one point in time directly with the CEO and another officer and director, and I did not include Mr. Fattal in that communication, but Mr. Fattal responded to that communication. So I feel very comfortable that Mr. Fattal represents GTII as he suggests. And he indicated that he was engaged January 16th, 2024 to be involved and help GTII complete a transaction. And that's close in time to when I contacted them. I don't know if that's cause and effect, or coincidence, but it is what it is. So after his letter, I become uncomfortable because I'm still uncertain of whether they're going to go forward. So I give them another opportunity. So I contacted them, and I have a couple emails here. I contacted them on the 12th of March, which would have been after my last video. And again, I basically indicated that if their 10K, as they had told me and as they had publicly indicated, did not reflect that there had been substantial progress towards completion of an imminent transaction, that I would not be the only one seeking remedies. And so I've indicated basically that if things are not as represented, I believe that's securities fraud. So I have to believe what they're telling me is truthful because they've reiterated multiple times. But time will tell. But I communicated to them, and I communicated that to the officers and directors. So they're all on notice of that. And I made sure to indicate also that if they tried to use some old, worn out transaction that was already dead to justify their current status, that wouldn't be acceptable. And that they would be bound by what they've publicly represented. And whatever they publicly represented is what I'm representing to you, because I'm just reading emails and reading letters. So I sent it out on the 12th, and I basically said, just so we're clear, if you're bullshitting me, you got big problems. Not the exact language I used, but that's kind of basically what it says. So I hear back, don't hear back, but on the 13th, just to be clear, I follow it up with my email, and I refer to the prior email, and I refer again, basically, that if you're BSing me, that ain't going to go over well for anybody. And I also indicated that on one particular transaction, apparently they had acknowledged that it was dead. So don't revive that one. And that's in there also. Same day, so this is the 13th of March, I get back a brief email from Mr. Fattal. He says, "Your persistence at this stage is really unnecessary. Please await the 10K for further information." And again, the 10K is what was represented that will indicate the details of the ongoing transaction that GTII is involved with. And that's per the letter that was provided to me. That's in conversation, and that's in the email I just referenced to you, the 10K. And it's in the letter dated March 6th that I read to you in the last video. So notwithstanding the fact he said that my persistence was not necessary, on the 15th, I gave him a day off. I contacted him again. And I, again, just made sure, based upon my concerns and based upon my concerns about that prior transactions had not been completed, that if what I've been told about their ongoing efforts and success to complete a transaction was not correct, that I thought that was extremely risky, especially for the CEO and the board of directors. And I also said, I doubt if those people want to spend, and I think those people happen to be elderly. I think the board of GTII is somewhat elderly, and I believe the CEO, some would consider to be elderly. And I basically said, I don't think those people want to spend their final days in court. And as it's ironically, the CEO lives and is based in Southern California, where I am. So theoretically, if I wanted to file an action against the CEO for breach of fiduciary duty or fraud or conversion, etc., I could file it in California and I could pursue the CEO in California. So I found that, an interesting fact. So they've made us several representations. I've let them and give them the opportunity to get out of that if they disagreed with what they had said, if things had changed. They have not. So I think they're in a box at this point in time. And the box is, and I don't, for my purposes and for our purposes, all your GTI shareholders, the way I see it is, it's one of two things. One, a transaction occurs and that transaction brings in revenue for GTII. It probably would have to be a stock acquisition or something like that. And if it brings in revenue for GTII, which I don't think has big revenues, that would be probably a positive event for the stock, and I would expect the stock to run. Alternatively, and it's the alternative, if this is all a line of BS, then I expect that the board and the CEO will resign or face serious consequences. And I feel comfortable, based upon everybody that's contacted me, et cetera, that if a new board and CEO were in place, that a transaction would be completed and that GTII would get a bump from that. So I feel good either way, but I've been promised and represented, and I've indicated to everybody that that's what's been said. So we will see what happens. Tomorrow is the 18th. I don't know if I'll be having contact from counsel, but we will see. And I obviously will keep everybody apprised. I believe the 10K, I've been informed, will come out on or before March 31st. And if, as promised, there is a transaction that is set to imminently closed, I expect the 10K will be detailed along those lines. So that's the current information about GTII as of today, March 17th, 2024, at about 5:30 Pacific time. Again, I wanted to be upfront about what's going on because I think it was fair. I oftentimes, most times, people don't know what's going on behind the scenes. I've obviously followed MMTLP and other things, and this way, at least you have what I see, and I'm trying to give it to you in real time so you have it. I can't vouch for the accuracy. I just vouch for the consequences. So again, they've been specific, so I feel comfortable that one or the other is going to occur. Now, briefly, I'm going to touch on Alpine while we're here. So Alpine is the broker. And again, a lot of people thought if Alpine goes broke or is expelled, that would be a trigger for a short squeeze. I don't know about that. But there is an appeal pending in DC about an injunction that was provided about a week ago, and I referenced it, I think, in a video. About a week ago, the appellate court, asked both sides to brief an issue about a particular statute. The statute permits the SEC to excuse someone from being a member of an SRO like FINRA and conduct business. And the Court of Appeal gave the parties about 2 weeks to brief the issue as to whether it applies to this case, the Alpine injunction appeal, or if it didn't. So we will get the final briefs in that March 31st. Expect a ruling, I'm sure, on that injunction within 30 days. So that's where that is. There's also a Utah appeal that was filed. There's no stay issued as of now, so there may be a request for a stay. I'll advise you of that. So in the end, I think Alpine's going down, as I've said many times, for their various misconduct. I don't know what impact it will have on the stock, and I don't know the time frame other than as I'm indicating to you. But I do feel otherwise, that if a material transaction occurs, that would have a positive effect. So that's why I'm communicating what I'm communicating. We'll see if it happens, not financial advice. Next, I wanted to talk about MMTLP. Before we get into MMTLP, kind of want to talk about insurance, because this is going to relate to the MMTLP class action that was filed. It also relate to something about Elon Musk. And it also relate, for everybody who has insurance, this might provide them some insight and provide them a little better understanding of what to do. So insurance, there's all kinds of insurance. There's general liability insurance. There's directors and officers insurance. And sometimes you'll hear me refer to D&O insurance. That's directors and officers. So that's insurance that might apply for officers and directors of a corporation or an entity. There may be architects and engineers insurance. That would be insurance that architects and engineers would get. So there's specific types of insurance that people can get. And policies generally can be occurrence policies. So whatever policy is in effect at the time of an actual event. So you have a car accident, you have a policy of insurance. That policy of insurance in an occurrence policy would apply because it happened during the policy period. The event happened. There's also a type of policy called a claims made policy. So that's not an occurrence policy. It's not when the event happened. It's when the claim was actually made. And under that type of insurance, it's whenever somebody complains, and if that policy of insurance is in effect, that's what'll cover the policy. Now, with regard to insurance, there's two main aspects of how insurance helps people. So people buy insurance if they can, and they buy it for purposes of covering claims. So if you buy car insurance, you hope to have car insurance to cover if you're in an accident, etc. So what about MMTLP? And I'm just going to bring you to there was recently a filing, and previously there was a class action that was settled subject to approval. It was actually two consolidated cases mediated that was settled and now has to go up to approval. So there's two basically benefits of insurance. One is extremely broad. So the insurance companies will look very broadly to provide this type of benefit. And the benefit is the duty to defend. So if you get sued, and if there's any arguable basis within the complaint to give you potentially coverage, they will defend you. What does that mean? They'll hire counsel for you and pay your legal fees. So if, for example, and this relates to the prior class action that was filed with regard to MMTLP, MMAT, I think it was two cases. It was resolved by mediation December for $3 million. Of that, and I'm just off the top of my head, $1 million was requested for attorney's fees, which left $2 million and I think $60,000 in cost, which left about $1,940,000. And that was going to be distributed amongst the shareholders who filed the claim. And I think it averaged out to 1.5 cents a share if you did that, if you followed that. So In that particular deal, it was indicated that not only did they defend, that's implied, but it indicated that out of that $3 million, the insurance company paid $2.85 million, which means that the insured paid about $150,000 of the $3 million, which is a 5% deductible in essence. So the first go around happens, a lawsuit is filed, insurance, what happens is you get a lawsuit, you tender it to your insurance company. The insurance company then either says yes or no. If there's fraud claims, and there were, and there are in the current action, or at least securities violations, what'll happen is you'll give it to your insurance company that will send it to a lawyer for an opinion about whether there's coverage. So another lawyer will look at the policy, will look at the claims, will look at any complaint, and will decide whether there's coverage or not. If they deem there may be coverage, then they will send a letter. They will indicate they will provide a defense, and they might indicate that they are operating under what's called a reservation of rights, which means that they don't agree there's any coverage, but they're going to defend you and we'll see what happens, but they don't think there's coverage. And there's no obligation to pay any settlement. So in the prior action, what they did is they did pay out the settlement. And because there was a fraud claim, my guess is they did it under a reservation of rights. And because there were multiple officers and directors, my estimation is that they were paying legal fees for all of those parties, and they would have to have different attorneys representing different defendants. So if you had, for example, 10 officers and directors who were named in an action, and the insurance company deemed that there may be coverage so that they had to defend each, they would have to hire 10 different law firms. Why would they have to hire 10 different law firms? Because the officers and directors might have different exposure. One may not have said anything. One may have been boisterous. If you settle out one, does that put the pressure on the others? So if you represented them all, how could you treat one different than the other? So you really can't. So as a result, you have to have individual counsel for each. So you can imagine the legal fees that would go up. So what's interesting in that prior class action that occurred, the settlement occurred after a motion to dismiss was granted. So the defendants filed a motion to dismiss saying that the complaint didn't adequately set forth any claims. They won, but the case was settled anyway after that, despite their victory. Now, they may have amended and been able to survive, but what most likely happened, and this is just my speculation to some degree, is the insurance company had paid out probably millions in defense fees and thought it was worthwhile just spending the money, whether it be $3 million to get rid of it. Now, even they're doing it under a reservation of rights, like I said before. So they're saying basically there's no coverage, but we'll pay it anyway. And you as the insured might have, although you don't necessarily have, might have the right to consent to a settlement. But if you don't consent to the settlement, then you have no coverage if the case goes to trial and you lose. So that's the risk. That's why most people, if the insurance company will say they will settle and they've said there's no coverage, they'll accept it and be done. So for the defendants in that case that settled, they're out. They didn't have to put up any money. Insurance paid everything. And for the insurance, even though theoretically the defendants might have won that case, for them it was super cost effective because they didn't have to defend a new round of complaints, file a new round of motions to dismiss, etc. So I think it was Saturday, Friday, there was a new class action. I think it was filed March 15th. Very bare bones complaint. The plaintiff's name was Taggart. I think I have the face page. Yeah, I do. So that's the face page of the complaint. It's Todd Taggart is the plaintiff. And in his complaint, I think it's on page 15 or 14, he has a verification saying that he's never been a representative. And I guess there's a question about whether that's true or not. But what's interesting to me, and what the impact is on that, but what's interesting to me, he also references that he's not getting he's not taking a bonus by being the named plaintiff, because he's bringing it on behalf or for the benefit of shareholders, obviously, or class members. Waits to be seen. But he says he's not. But in that same verification where he says he's not requesting, he says, but he'll accept whatever remedies the court orders. So if the court orders that he gets an additional fee, he'll accept it. So I found that somewhat disingenuous. But basically, this action claims that the registration statement that was filed was inaccurate with regard to the valuation. That's basically the claim. There may be some other, but it's pretty bare bones. And I'm sure there will be motions to dismiss. And I believe it's the same firm that handled the prior class action that I was referencing that settled for $3 million. Now, this action names NextBridge Hydrocarbons, and it names, I was just kind of joking around about the 10 officers and directors, but this one actually does name 10 officers and directors. And just kind of thinking out loud, if I was a plaintiff's class action attorney, and they throw a lot of darts, they might file many cases, most may not work, and they hope to hit a home run. And just because they file an action and make allegations, those aren't facts. So you shouldn't make a determination just because someone files an action that it means that what they claim is true, just allegations. But if they had been involved in the prior lawsuit and insurance had ended up paying out monies in settlement after defendants won a motion to dismiss, as a plaintiff's attorney, I would think that even if I have a losing case, these bozo insurance companies who have to defend separately 10 officers and directors and NextBridge Hydrocarbons, it might be cheaper just to pay out a sum of money than to have to hire 10 law firms, engage in lengthy litigation, where even if they win, they lose financially. And so that's when I saw that, and the 10 officers and directors, that's what occurred to me. And do I have any experience in this? I do. When one of the savings and loan crisis, I think back in the 90s or 80s, yes, I've been around that long. The firm I was working for at that time before I became a solo, we represented a bunch of officers and directors, as did other firms that had a savings and loan that went bust up. And all these individual officers and directors were represented by different law firms. And in the end, the amount of legal fees that were paid was substantially more than the amount that was paid in settlement. And the amount in settlement was multi-million dollars. I don't remember what it was off the top of my head, but let's say they paid, and this is way back. So let's say they paid $20 million in settlement, but they may have spent like $40 or $50 million in legal fees. So I have experience in that. So when I saw the officers and directors, it made me think that this is just a straight attorney's fee insurance game. So do I know what the insurance is of NextBridge Hydrocarbons? No, I don't. But if MMAT had officer and director insurance, or insurance that covered the class action allegations that were made in the prior class action, enough so that there was at least insurance involvement that paid the settlement, it's very possible that NextBridge has the same setup. So either NextBridge has liability insurance, which would cover NextBridge. Perhaps all the officers and directors are additional insureds. So what that means is you can have a policy of insurance for X, but you can name additional people to be covered. So do they have a liability policy that names the officers and directors as additional insureds? Perhaps. Or do they have officers and directors insurance? I'm guessing that's the case. And therefore, under those circumstances, some insurance company is going to have to pay a boatload of money, and plaintiff's counsel knows that. And if you're a class action attorney and you know that, and you know there's a guaranteed pot of money to cover your legal fees, I think you'd be compelled. Now, I don't know the facts, the ultimate facts of the Taggart, or actually it's Targ Art. Didn't realize that. Targ Art. Targgart, unusual spelling. Now, I don't know the details. I don't know if it's true. I certainly didn't rely upon the valuation or the registration statement when I bought my shares much later. I don't know if anybody else did. I don't know if Mr. Targart did. I don't know if it's material. So I don't know the truth of the allegations. I'm just saying the practicalities. The practicalities in law is a lot of times insurance and attorney's fees are what control the matter. And when I looked at this particular action, that's very skimpy, but basically alleges a improper registration statement. And at one point it says it's inaccurate. And so insurance can cover intentional acts, but if it's just inaccurate, that would be an allegation that wouldn't necessarily be for intentional misconduct. So if I'm the plaintiff's attorney, I think, oh, I can get insurance on this because there's an allegation that is not intentional conduct. So when I saw that particular class action, and by the way, it'll take at least a couple of years if it's going to go forward to some trial, at least 2 years plus. And to get through the motion to dismiss stage, so what I discussed about the prior action, here, all the defendants, after they have their attorneys will prepare some type of response. It can be either an answer or a motion to dismiss or a motion to strike. Most likely it'll be a motion to dismiss. It'll say, in essence, the allegations of the complaint are not sufficient. The court will either say yes or no. They'll either give them a chance to amend the complaint or not. If they amend the complaint, they can file a new complaint to address whatever deficiencies are. But if this case follows how the MMAT, MMTLP class action settlement went, after the hearing on the first motion to dismiss, there may be a resolution. And that may be whether the motion to dismiss is granted or not granted, because the insurance company has already indicated, or if it's the same carriers, a willingness to pay to get out of here. And again, here they're going to have at least 11 parties to defend. If they have 11 parties to defend, you can imagine, not with any sympathy to the insurance companies, but you can imagine what the possible cost would be to the insurance companies. So they're inclined to work in their best interests, which would be to settle the cases. And just because there's a settlement does not mean that something's true. As a matter of fact, and this happened in the prior class action, there's no admission of liability, and I think there was no factual agreement to the basic facts. And that's common in settlements that are not confidential. There's no admission of liability, so you can't take the settlement agreement and use it in another case. That's different than if you get a judgment against someone. So if you went to trial or otherwise were able to get a judgment, like Capybara, there's a judgment against Capybara. If you're able to get a judgment, then you can go after that right away. But if you're not in the judgment, you actually have to go through the proceeding. And to get it to a trial in a class action usually takes a long time. Now, am I a big fan of class actions? No, I'm not a big fan of class actions. I think that's the last thing that should be, because I don't think the plaintiffs usually do well. But if it applies, it applies. But I've spoken to JR about this. I've spoken to many people that as to MMTLP, MMAT, NextBridge, it's inevitable that class action lawyers will seek out plaintiffs, because they seek out plaintiffs in every case, whether the stock's doing well or not. And because of the extraordinary circumstances of MMTLP, it's impossible for plaintiffs' attorneys searching for attorney's fees not to come out of the woodwork. So it doesn't change my opinion as to the position of MMTLP. And even though I know it is impactful when you hear about it, try not to assume that the information is true. If the allegations turn out to be true, we will all know. It'll all come out. But just because somebody files an action means nothing. Just means they're filing an action and going forward. And again, in this case, the insurance company is kind of led and told plaintiff's attorney, we'll pay you money, so go ahead. So that's why I view the Todd Targart matter class action as I do. I think in a post I put a yawn. I'm not making a determination of facts because I don't know the facts, but I think, again, it's driven specifically by legal fees and insurance, and I think it will be ended by both. I don't think, currently, I don't know how it will end up. I don't think it impacts the MMTLP cause. Well, let me back that up. I don't think it impacts MMTLP in terms of the facts. Facts are the facts in terms of the U3 halt and how we got there. So I don't think it impacts that. If somebody thinks that it does, then I would love to have a conversation with them. I don't think so. How it turns out, how the litigation turns out, we shall see, but it doesn't impact me. It doesn't change my position. So that's how I will view it. I think I'm on Tuesday night with Drew. I'll be discussing the class action aspect also. And again, I'm not saying that if you're a plaintiff or if you're a owner of NextBridge and you have concerns, should you check out your concerns with an attorney? Why not? There's nothing wrong with that. But to this point in time, based upon the conclusion of the last class action, based upon who's involved in this one, it hasn't changed my position. So if it does, I will certainly let you know. And I just kind of want to deal with one last aspect. So that's MMTLP. I wanted to kind of deal with one last aspect just to give you a perspective on class actions and why I think they're attorney driven. And I also follow Tesla, and I've done some live streams with others on Tesla and some of their legal things because I follow that. And recently there was a case in Delaware where Elon Musk pay package of approximately $55.9 billion running from Tesla options that he received as pay from 2018 through 2023. The court deemed in a lawsuit by an investor who had 7 shares done for the benefit of Tesla that was represented. They brought an action and they tried to rescind the grant of shares to Elon. A couple years passed. There was a trial. The judge ruled in a 200-page opinion, starting off with, is the richest man in the world overpaid, with a completely inappropriate sentence, by the way, in a 200-page opinion, the very first line. She ruled, and she had ruled against Musk in the Twitter deal, that he was obligated to buy Twitter at the price that was indicated. But she ruled that pay package was unfair and needed to be rescinded. In other words, back to 2018 without a pay package. So in that case, what happened is the court granted that, rescinded the package, asked the parties to get together to try to figure out an agreement as to a judgment. The plaintiff's counsel filed a motion for attorney's fees in the class action, upon which they had a contingency fee case. And Delaware had certain rules by which you could calculate an attorney's fee. In California and other states, the way you calculate, or most often calculate, an attorney's fee in a class action would be based upon the number of hours spent times a rate, a reasonable rate based upon the expertise of the person. So just for convenience sake, you worked 1,000 hours, $100 an hour was your rate, that would be $100,000. If $1,000 an hour, that'd be $1 million. That'd be kind of the way it would go. In Delaware, it's based upon a percentage of the value of the benefit. So in this case, what the attorneys are claiming is the benefit that was obtained, in other words, not letting Elon Musk exercise the options on those shares, went back to Tesla. And Tesla received that benefit. And as a result, the attorneys were entitled to an award. What did they calculate that award on? They calculated, as opposed to a monetary award, and there was directors and officers insurance. So that would have paid my financial award, but they didn't ask for that. They asked for stock. So they asked for Tesla to give the attorneys approximately $6 billion in stock. So that's being litigated right now. So the attorneys have asked for $6 billion in stock that somehow benefits Tesla, even though it dilutes Tesla shareholders, and Tesla is about to respond. So when I say in a class action that they are often driven by insurance and attorney's fees, that Tesla case is one such action. And in that case, maybe for spite, maybe other reasons, plaintiff's counsel is avoiding the insurance that might pay a substantial monetary amount, and is instead, based upon the fact they're concerned that if Tesla had to pay a monetary amount like that, it would impact their day-to-day operations. And instead, they're wanting Tesla to pay on the order of 29 million shares of Tesla stock, something on that order, to these attorneys for winning, theoretically, for the benefit of Tesla. But Tesla has to pay the shares. So seems like an odd setup, but the attorneys will be the winners in that case. Nobody else. The attorneys. Oh, and the plaintiff. In that case, the named plaintiff with 7 shares of Tesla stock will get something like $10,000 to $15,000. That's why Todd Targart, in the action against NextBridge, made a reference about not receiving anything. That's what he's referencing, because he doesn't want anybody to believe that he's just a whore out for money, even though I think he claims to have 16,000 shares, something on the order of NextBridge shares, and he obviously wants money. So I didn't really find his declaration compelling. So, but the Tesla matter kind of demonstrates for you why these class actions go forward. And most of them are unsuccessful. Most die because they die motion to dismiss, but some have legs. And like I indicated, in the Targart matter, NextBridge, the insurance company may have led inappropriately and kind of told them, come ahead and sue us because we'll pay you. So that's that. Last but not least, if anybody has any questions, I'm looking at the comments and I could see out of my left eye, I'm just going to put this up there. I see that GTI to the moon. I have no idea if it's going to go to a moon, but if a transaction is consummated, I think that would be good, not financial advice. If the board and the chief executive are replaced by competent people who consummate a transaction, I also think that's good for the security, but we shall see. And they said March 31st was the date, the relevant date. If March 31st comes and they haven't really done what they said, then I've indicated that I'm going forward with legal action. And obviously with the MMTLP, that's exactly what I did. So I don't know why they would doubt if I say I'm going to do it, I'm going to do that. So I would expect something before March 31st, because that's what they said. Briefly, I was going to say I'm involved in the arbitration involving MMTLP. I try to keep everybody apprised, just bring everybody up to speed in that arbitration, which is ridiculous in terms of how it's conducted. I've kind of indicated why. The arbiters, the system, the cost, discovery, what else? And that's the remedy for investors. So if you have a brokerage and you have an arbitration provision, you're basically stuck with that. Hopefully, in what I'm illustrating, we can get some change in the system. Obviously, I want to win the case. And if it requires going up on appeal, I understand that's a possibility. But I also would like to change the system so that individual investors, if they go to arbitration, won't get screwed and it won't cost them a fortune, because it basically keeps small investors from having a remedy. And that is completely unfair. And I don't know why it's not taken care of. So most recent communication regarding my arbitration was with the director of FINRA arbitration. Two things. One, based upon the declaration that the chief arbiter, who doesn't allow hearings and doesn't give any reasoning for rulings, based upon his representation that he's not biased, I had to conclude that he had a mental deficiency. And based on that, I asked the director to conduct a mental examination of him. I have not yet heard back from the director, surprisingly, but I will certainly follow up. I only asked for the mental examination based upon the performance of that arbiter, and this particular arbiter is the chief arbiter who decides everything up until the hearing. So there's three arbiters. The central arbiter, who happens to be, I believe, 81 years old, as it turns out, he decides everything up until the hearing. That means if someone like me asks for discovery because of extraordinary circumstances, based upon a U3 halt, based upon a November 15th, 2022 letter that says that Fidelity can't sell MMTLP shares, etc., based upon that, I asked for discovery, no reasoning, no hearing, just a denial, flat. And I've probably asked for about 15 things, have about 15 filings for various forms of discovery, including with regard to that letter. So just to be upfront, Fidelity and their counsel didn't produce any documents. And I basically said, produce any documents that's in 2022 in which Fidelity basically said they couldn't sell MMTLP shares. I knew I had this letter, this email that said that. They said that nothing existed. I filed a motion. I said, here it is. So even if they claim it doesn't apply, the request specifically asked for that, and I'm not going to let them decide what's applicable or what's not, especially if they have a confidentiality order, and there's a confidentiality order in effect. So, and the reason why I don't show you documents related to the arbitration is because I can't. So I can talk about the arbitration, but I can't show you that. So despite that, they don't provide the documents. So because the arbiter doesn't provide hearings, doesn't provide reasoning, and seems to act in an illogical way, but acknowledges they're not biased, and I have to assume at an age of 81, they don't have the mental competency to act in that capacity, and charge thousands of dollars for their services that are questionable at best. So therefore, I've asked for a mental examination. On top of that, based upon and arising out of the same thing, because there's no satisfaction that I receive and anyone receives in an arbitration, the way it's set up. Because how can you prove up a case where the documents are withheld? So in the MMTLP case, how could I possibly personally have the share count? How could I have that information? So if I ask for the share count, which I've done, why shouldn't I receive them? Because if I don't have access to confidential information of FINRA, how could I prove up a case where FINRA is involved? Doesn't make any sense. So because of that, and because the arbiter has said he's not biased, and the other ones have said that too, and they said they'd be willing to consider naked shorts and counterfeiting, the only conclusion is there must be mental incompetence. So I've asked for that. The alternative I've asked for the same reasons, and because these proceedings I concluded have been a sham, I've asked and I've told the director that I'm going to refuse to pay any of the fees that have been incurred because it's a sham. I'm not going to be subjected to paying fees in a sham arbitration. I don't know what those fees would be. It could be $20,000, $30,000, to be honest, based upon the amount of testimony. And that would be my share. So if someone's going to basically steal my time, I'm not going to be obligated. So I've indicated to the mediator and to the director that I'm not going to pay the fees. And if they don't resolve that in some fashion, I didn't really give them a how about to resolve it. I'd file a new lawsuit contesting my obligation to pay fees. So I'm not going to contest the arbitration because I'm in the arbitration, but I'm going to contest and I'll file an action and I'll say basically, I'm required to participate in an arbitration. The arbitration is a sham. I am responsible for costs. In a sham arbitration, I should not be required to pay. So court, please give me a declaration that I'm not obligated to pay. And that's not contesting the arbitration provision. That's just contesting upfront my obligation to pay. Have not gotten back a response from the director of FINRA arbitration, and we'll see what happens. So that's up to date in terms of FINRA arbitration. So with that, unless somebody had, exactly, somebody, and I'm not going to say whether you like the candidate or not, but to be honest, when I saw, and it doesn't mean that you can't be super competent, because I knew this Holocaust survivor who passed away last year. He was 106 years old. He was competent up until the last years of his life. So at 81, he would have been a super president and super on the ball. Not everyone at 81 is on the ball. And unfortunately, based upon my dealings with my arbiter's not on the ball. So just kind of going back over what we talked about. We talked about GTII and how I saw what was going on, giving you my up-to-date personal experience that I've thought that it's been multiple times where I've given the management and their representatives an opportunity to say no deals going forward, they're not involved in the deal, there's no entity, and they've continually accepted that there is a transaction and that transaction is ongoing and that the 10K will provide us further detail as to that ongoing transaction that will close in an imminent period. That's what I specifically asked. And my conclusion is that if that's not true, that would be securities fraud. And I've been reassured multiple times, so I have to, at least for now, believe that's true. And if it's not true, I'm going to go after them, and I won't be the only one. So again, have to believe it's true. And then we talked a little bit about the class action involving MMTLP and insurance and various types of insurance and what it might cover, whether it just defends you or it provides for the settlement. And we talked about the prior class action that was settled for $3 million and the current class action and how that insurance and attorney's fees often are the controlling thing that move those cases, even though I really don't know the facts and the facts haven't been developed. Then I talked a little bit about Elon Musk and the lawsuit that was brought about against him and the attorney's fee request in a class action for $6 billion in shares. And then last but not least, I talked about my arbitration, the current status, where we are and what I've asked for. And I think that's about it. If anyone else has any questions that they want to quickly ask, I will certainly take them. But otherwise, we'll just leave it there. And when I have some new information about GTII, when I have either new communications or no communications, I'll let you all know. I will try to let you know, certainly before the 10K comes out, so you have an idea about whether they've been in contact, if they've changed their position. I will let you know about MMTLP, and if my view changes on the class action, I'll bring you up to speed on the arbitration. I'll bring you up to speed about Alpine when the new ruling comes out on the appeal. And I think that's it. So let me see if, is that a question? Let me see if that's a question. So the question is, are the recent class actions inconsequential to the eventual MMTLP outcome? It remains to be seen. Some attorneys had some concern about the language in the first class action. I think they were going to iron out so there was no confusion. I don't think it was intended to impact MMTLP, the future outcome. There was just some loose language. So I think that's being rectified. In the current action, it's too early to tell. There's no resolution. We don't know what the class is. The allegations are pretty sparse. There's no discovery. So I think it'd just be guesswork. As of right now, it didn't concern me, but would it in the future? We'd have to see. So that's kind of how I view that. Hope that helps. I know it's a bunch of legal mumbo jumbo, but that's kind of how I see that. Somebody asked if, let me put this up here. No, I wasn't trying to put that one up there. Somebody asked Thomas Z. Thank you, Thomas. My parents were Polish. That looks like a Polish name, by the way. Ask me if I transfer, you transfer your shares to AST and there's a settlement, will you still get a settlement? So that's a guess. Nobody knows for sure. Most people think that if there was a settlement that all shareholders would get some resolution. If I could transfer all my shares to AST, I would. Because I'm in arbitration, I'm reluctant to. I have asked my attorneys being Fidelity attorneys, to transfer one share to AST. They have indicated they're not going to, but they gave me a name and number to contact to do that. Maybe I'll put that out. I don't have it with me, but maybe at some point in time, I will put that out, that name and number at Fidelity to contact. I haven't been in contact with that person. So if it were me, I would transfer. I wouldn't be concerned about the settlement in terms of that. But if you're really concerned, that's not legal advice, of course. But if you're really concerned and you have enough shares, and it means so enough to you, then find a lawyer and just ask the question and make them responsible. So in other words, if you go to a lawyer and you ask them this question and they tell you the wrong answer, and because of that, you lose money, then you've bought insurance, the lawyer. So if it's worthwhile, that's how I would look at it, just buying insurance. So again, if it were me, if I could, I didn't feel any concern that if I moved all my shares to AST, that my arbitration with Fidelity might be impacted, I would. But that's kind of where I am. So. With your conversation with Drew will be on Twitter. I think it'll be on the Spaces. I think, as far as I know, it'll be 6 p.m. Pacific on Tuesday. this coming Tuesday. And I saw Drew did post something about the class action that I saw, and it looked pretty good analysis. So I think it'll be an interesting conversation. Looking at any other questions that anybody has. If not, just so we're clear, after this, I always look at the comments. If you've commented, you'll see, because I'll always leave some indication that I've looked at it. And if I have some information that I can add that makes sense, that's in English, I'll add that, or at least try to. So if after this you have some question you want to ask, then do so, and I will try to respond. I've also thought about it, and we'll see what we do. I've thought about setting up in the future maybe a separate group, and maybe once or twice a month in the separate group, and it would be a paid group, but it would be a small fee. I haven't decided how to do it yet, because it's got to be worthwhile to the people who are going to do it. But kind of what I was thinking is these people would send me their legal questions, their personal legal questions that they were happy to have considered. And in a session, somewhat private, we could go over them and I could answer not legal advice. We can kind of give people some specific information, but I don't know how it's going to be done, if it's going to be done, but something that occurred to me, because it might be able to, as opposed to giving you more general information that I do here about limited topics, it might be valuable to people if they have specific concerns. If those are addressed, and maybe other people would be able to kind of use that to, thank you for the hello, by the way, Thomas. If other people might be able to use that for their only benefit. So just that's something I'm thinking about. In the meantime, obviously, I'll keep you apprised as to everything that we talked about, all the matters that we talked about. I hope everybody stays well, be well, take care. Everybody try to, stay busy, focus, be productive, and thanks for watching, and see you soon.